Mr. Chairman and members of the committee, Senate Bill 1323 is here to build on some work that was done last year. I'll start by saying 59 million Americans earned some or all of their income in the last 12 months from independent work. And we're all familiar with the independent contractors. Some are architects, beauticians, real estate agents, musicians, and journalists, but more specifically, especially in COVID, they were Uber drivers and Shipt and Instacart and Grubhub and Amazon drivers, truck drivers, and taxi drivers. Last year, there was some work done with House Bill 1199, House Bill 984, and 1407, which worked to give cause of action rights to employees, to more clearly identify the responsibility of businesses to ensure that employees were not misclassified. And this bill works to build on that work. This bill would protect full-time and contract workers, and with them having their rights of action, but with language that defines more clearly what contract workers are. It's confusing right now. It helps provide more concrete employment criteria for Virginians to follow, ensuring that both independent contractors and businesses have the clarity they need to comply with Virginia law. So just some specifics about this bill and what it does. It includes the common law right of control test established by IRS, which is referenced in those other bills. It includes a contract that states the engaged individual is self-employed. It gives that individual right of control, meaning they're solely in charge of all methods by which their work will be accomplished. There are other aspects to this which are clearly in the bill, but all along the same lines. Basically, it helps Virginia avoid some of the missteps and fallouts that Californians are experiencing after AB 5 because it provides more certainty for businesses and independent contractors to avoid those misclassifications with a clear criteria, and it protects both so that the independent workers can have security in their job and not be classified as full-time employees, which they do not want, but also holds the employers accountable that they can't misclassify and therefore have a misappropriation of taxes or other responsibilities. That, Mr. Chairman, is the bill before you now. Thank you for your patience.
Questions of the patron by members of the committee?
Yes, Mr. Chair.
Senator Barker.
Yeah.
Senator Barker.
Senator Dunnavant, if this goes into effect, will the IRS and other federal agencies basically defer to our classification system here, so that as long as someone is consistent with what's in Virginia law, they would be categorized in the same category at the federal level, or is there going to be some disparity between the determinations?
Mr. Chairman and Senator Barker, I believe that there are maybe people that can clarify that better than me, but my understanding of the bill is that we actually are adopting the IRS language, and then there are giving some additional specifics of how to clarify the relationship between an independent contractor and an employer, but I don't think we would expressly in any way be contrarian to the IRS language because we're actually adopting and referencing that.
Any other questions? All right, we go to public part of the bill. Those who support...
Mr. Chairman, Mr. Revelle.
Scott, Senator Servo.
Thank you, Mr. Chairman. This is, I guess, a question for council. I'm trying to understand how this statute bill is constructed. So I guess it's under Title 40.1, which is, I think, labor and employment or something, but the statute we're striking says that the definition that's being struck, it only applies to this section. So it says, as used in this section. So I think it's on line 26. And then, but it's being replaced with the definition which does not seem to be limited to this section. And I know one of the issues that we litigate about, not just for employment context, but for vicarious liability, and whether it's car accidents or generic torts, there's a huge difference between somebody being an independent contractor and an employee for which you're vicariously liable. And by removing the language that this definition only applies to this code section, I'm wondering sort of whether this would have a much broader impact than solely the employee-employer relationship for benefits purposes.
Mr. Chairman, Senator Seslaw, you are correct that there is no limitation language in the bill, or in subsection C, rather. I would point out that in subsection D for litigation under this section, subsection D is limited to this section, but subsection C is silent on that issue.
Mr. Chairman, further question?
Senator Saravel.
So didn't we just pass a bill last session about, or actually probably 2 or 3 different bills about worker misclassification and causes of action having to do with worker misclassification and giving the employment VEC more authority to deal with worker misclassification, all that? I mean, this kind of goes to the heart of that, right?
Mr. Chairman, Senator Serval, yes, you passed a bill last year that created this section, creating a cause of action for an employee who is misclassified.
Mr. Chairman?
Senator Edwards.
Yeah, I'm similar questions. I'm wondering why we need the bill. I mean, and it's pretty clear what an independent contractor is. The IRS has its own definition. What's the purpose of the bill? What's the point of it? Because there's a big difference between an employee and an independent contractor, and I think I understand what the difference is. So what does this bill do that the common law doesn't already do? Or do you know?
I think that it protects the power of the individual to be individually employed. And so I think that there have been conflicts in other states and misunderstanding with a failed clarity of the definition of what is an independent employee. And I think it seeks to make sure that as I understand it, and again, we're not talking pap smears here, but as I understand it, this is actually to help clarify and support some of the actions that were taken last year to seek to limit misclassification of employees. Most of that was weighted towards defining contract employees, and defining full-time employees, and this is more defining contract employees.
Mr. Chairman, it makes a big difference in terms of tort liability. You're responsible as responding to a superior, it was a technical legal term, for the acts of your employees, but you're not responsible for the acts of the independent contractor. So it could have large, plus there's also the question of benefits. I mean, I'm reluctant to vote for a bill that I'm not sure what it really does and what the point is.
Mr. Chairman and Senator Edwards, my understanding of the bill is that it does not in any way create increased liability for the businesses. It actually makes it very clear that it's the responsibility of the independent contractor for all of those responsibilities that they have, independent of the business.
Mr. Chairman, and that's the reason I would not support the bill. You couldn't sue the employer because the person's an independent contractor. You can't sue the employer for the acts of the independent contractor, but you can sue the employer for the acts of an employee.
I might have to have one of the people I have online answer that question for you.
Mr. Chairman, Saravel, I guess I think this question's for council too. So, okay, I'm looking down at subsection D now, and which lines 178 to 82, which smells like a lot of stuff for the Judiciary Committee, not this committee, but it basically says that, first of all, it says that a hiring party alleging that something's filed in connection with this being frivolous or improper may file a motion to dismiss. Number one, I'm not aware of any prohibition on filing a motion to dismiss a frivolous claim right now, today, under law. So I'm not clear why that sentence is necessary. And then it also says that if an employee signs a contract with an employer that states in the contract, I'm an independent contractor, that you can be sanctioned under 801-271.1 for filing a lawsuit under this, which to me it's like saying the employer just gets to contract themselves out of court which to me is wacky. I mean, do you know of any other precedent in the code for something like that?
Mr. Chairman, Senator Serval, I do not know of any other precedent for that.
Mr. Chairman, I think this is more appropriate for the Judiciary Committee. I move we re-refer to the Judiciary Committee to deal with all these issues.
Mr. Chairman, I think I've had people waiting to speak during committee if it's possible.
They're going, we got a motion before us. The problem is they're going to speak, and then they're going to have public testimony over
Okay.
there. So
Got it.
there's a motion. Is there a second to refer the bill to courts of justice or judiciary?
Second.
All right, there's a motion and a second to refer this to the judiciary. I think we have to record this, don't we? All those in favor of referring it to Judiciary Committee, vote aye. Those who oppose, vote no.
Ayes 14, nays 1.